Hi everybody, USCIS just released a bombshell announcement that they are going to increase filing fees across the board, where some visas are going to see their fees jump over 200%. H-1Bs, I-485s, the EB-5 visas I-526, and the 829, all of them seem to be getting hit. So before any big changes though, Congress requires a 60-day comment period where we hope to get some big questions answered. Things like, why is this happening? What is all this money for? What do we get in return for paying almost double our fees? There are some other questions that the industry is also asking too. Historically, if you give more money to USCIS, does performance actually improve? Do processing times actually come down? Whenever USCIS makes big policy moves, I like to bring in my partners Peter Bibler, our Managing Director and Licensed Immigration Attorney, as well as Greg Sheehan, Director of Investor Relations and a Licensed Immigration Attorney, and even a former USCIS adjudicator at IPO. We did a quick roundtable discussion about the fee increase proposal, which fees are getting hit the hardest, what it means for the immigration world going forward, and a whole bunch more. So it's a detailed discussion, so I put the separate chapter links in the description below so you can kind of jump around and see what you want. I also put any reference materials and the actual fee proposal down in that description as well. So please like this video if we've saved you some time, saved you some money, or if you simply just learned something useful. As always, if you have any questions, just throw them in the comments and we'll definitely get to them. So here are those experts. Hello, Peter and Greg. Happy New Year. So welcome back to the working world. And then all of a sudden we have a massive fee increase from USCIS that hits our mailbox. We're looking at some major changes in the cost to do anything in immigration. So wanted to get on the phone with you guys and find out what you've seen, what you think of this, and then also kind of what are the moves going forward on this thing. Because it looks like a proposal for fee increases. So we need to talk about what that means to us and when these things are going to hit. But Peter, you had a chance to read through this thing. Like what are the major changes on this fee increase proposal from USCIS?
Well, across the board, you're seeing about a 40% increase as a weighted average on fees across the board for immigration filings. And we're seeing the most substantial increase in the employment-based, as particularly EB-5. So you're seeing the most substantial increase in the I-526 petition, or what's the I-526E petition, where it's more than doubling from just under $4,000 to more than $11,000 to file the I-526 petition. Many of our investors are filing concurrently with the adjustment of status. That is the I-485 petition. And we're seeing a modest increase of about 25%, 26% from just over $1,200 to over $1,500. And what's notable here is that children under 14, are being charged the same as adults, so that you're seeing like 100% increase in fees for adjusting status for children. The work authorization EAD forms, you're seeing a modest increase to about $650, and for the travel documents, you're seeing again a modest increase there. So we'll just back up.
Yeah, well, the EAD, I'm seeing a 35 to 59% increase. Online versus paper processing, $410 to $550 or $650.
I see the advance pro.
Yeah.
What we're seeing in EB-5 most significantly is a huge increase in the I-526 petition, where it's more than doubled. So if you want to file in the future, when you want to file an I-526E petition, it's going to go from just under $4,000 to over $11,000 for that petition. Many of our investors are looking to file their adjustment of status concurrently and apply for EAD, work authorization, and advance parole for the travel documents. And we're seeing increases there. Most notably, children under 14 are seeing a 100% increase, so they're being charged the same as adults for adjustment of status. And overall, you're seeing about a 25 to 30% increase across the board for those adjustment of status forms. The 829, so for many of our investors who are now, have gone through the full process and are filing for that permanent green card or to remove the conditions of their green card, you're going to see about 150% increase in fees. So again, it's just under $4,000 now for the I-829 petition. In the future, it'll be $9,500. Thereabouts.
Well, it's a significant jump. Is that that's one of the biggest increases of all the categories? And it looks like it's only short of one other form, which is our famous 956 form. So significant.
Yeah, the 956, you're seeing an increase. For the audience, the 956 is the application for regional centers. And historically, that's just been about just over $17,000 for that form. And all regional centers, after our lawsuit earlier this year and after the passage of the Reform and Integrity Act of 2022 in March, all regional centers who wanted to continue to operate and sponsor projects and offer investments, qualified investments for the green card to foreign investors, had to file this form, and that's historically been around $17,500, $18,000. In the future, going forward, it'll be roughly $48,000. So that was one of the most significant increases for internally, for the industry. But for investors, our EP5 investors, they're going to see significant increases in the future.
Yeah.
Yeah, I mean, we can see where the pain points are, where USCIS is looking to deliver on its obligations across the board. Obviously, we know in USCIS that we don't charge for humanitarian benefits, so you have to subsidize that cost with other filers. It's not appropriated by Congress. And, they did increase some family-based, as you mentioned, but the biggest increases here are employment-based, and specifically EB-5. My frustration as I look at this is you segmented out the work of the regional center form type that used to be I-924 into now the alphabet, and all those are getting fees that should be lined up with the work that's appropriate for what those alphabet letters are. But the 956 that has most of that work stripped away is they want $50,000 almost. It just seems like highway robbery. You're coming in asking for more to try to get less. Like, what is this negotiation tactic? There's no credibility in my mind to be able to justify the cost of a 956 that took me a week to do if I was slow and doing nothing else. This is not a difficult form. There's website scraping involved, and there's vetting, and there's processes, but this is not a lift at all. There's no project analysis when a regional center is simply filing a 956. You're not looking at individual investors. You're not looking at job creation. It's a very simple form. So to me, this is the biggest ripoff of the whole thing. And they will come down or they will get sued because there's no credible justification that they could spit out in front of a judge that this form type should be this expensive.
Yep. Understood. So, like looking at this, it is a proposal. It got, shot across the bow. Now it is going to move through its processes. Peter, what does that look like for a proposal to actually become final and a check that you actually have to write?
Well, you're right. This is a proposal. So officially, it's a notice of proposed rulemaking. So this is the Administrative Procedures Act, where they are publishing this proposed rule, and which they did yesterday. And now we have 60 days. We mean the public, including EB5 investors, lawyers, regional centers, all stakeholders in the EB5 community now have 60 days until March 3rd to submit comments. And we can put a link in the to the actual text, the proposed rules, so you can take a look at it. It's a beast, I don't know, 400, 500 pages.
Right. Yeah.
But that way you can take a look directly, and there will be two things. One, you have the opportunity to submit comments with USCIS until March 3rd. And this is important part of the rulemaking process because USCIS needs to record all those comments and they'll need to respond to those, respond to those comments in some way when they publish a final rule. And it also produces a record. And this it was important to us in the past, in our litigation efforts with USCIS, when we were challenging certain actions taken by US in the past. Those records are valuable resources for litigation and for holding USCIS accountable in what it does.
So essentially, the notice and comment period and the comments that are submitted by the public can be admitted as evidence in a later litigation if it's relevant?
If it's relevant. I mean, there's some technicalities there about how it's used and such, but it can be a relevant resource to inform the parties and the court. Yep. The other aspect here, and so what that means, this 60-day notice and comment period is that this rule is not going to go into effect. These price increases are not going to go into immediate effect. For people, but so it's going to occur sometime after 60 days. So they're going to take those comments and they're going to reformulate. If maybe they may not, but and then they'll publish a final rule, and the fee schedule will then take effect. So there's still that process. And additionally, another opportunity for viewers to participate and give feedback includes a listening session. So USCIS just announced today that they're going to host an online listening session on January 11th at I think, what is it, 2 o'clock Eastern time. We'll put a link in to register.
An hour.
Yeah. And there again, they're not going to answer questions.
Yeah, I was going to ask you, tell us the difference between listening session and engagement call, right?
Right. We've had a couple of these listening sessions earlier this year, during the implementation of the Reform and Integrity Act. And in each case, callers and lawyers, regional senators, representatives, operators, investors, get in line, queue up to make a comment on the phone and ask a question, but that question is not answered. It's just recorded and noted, duly noted. And what's done with that, we don't know. But it's at least going to be an opportunity, a platform to voice any concerns about these fee increases.
Understood. Hey, Greg, you mentioned earlier, it's like you can see the pain points of USCIS. Like when you're reading the tea leaves off of what you see come out of this, like what do you think this translates from? Like what does USCIS mean with these numbers?
Yeah, I think the old philosophy here has always been, when I was there, is that to subsidize the humanitarian form type, you need to use employment-based, because you feel like there's more money there. You feel like there's more disposable income when you can have an expense of an employee gained as opposed to the benefit of a family member. That's also very important, but now it comes down to personal finances. So the general theory is that every business can afford more than a family can. Not always true. It's going to hurt people more than others, but that's generally what it comes down to, is they try to fill the gap with employment-based funding.
Okay. And, from somebody that is an investor, a developer, and, essentially job creators, we look at this thing and it's like, if you have, the 140,000 green cards every single year and only 7% is allowed to come from EB-5, but you look at these fees and everything, and it looks like they're funding a whole lot more than 7% out of EB-5. And it doesn't look very intelligent from an economic standpoint, because it's kind of like, well, if that's your moneymaker and if that is creating ultimate economic good for the economy and job creation, you might want to boost the supply of those fees. And that, it's a whole other story for a different time on the quotas and the backlogs. But, kind of moving on to the next question on this thing, we were expecting a fee study with the RIA policy in 2022. Right. The fee study was going to promise us that if we charge you through the face and you pay thousands of dollars for fees, you're going to get 90-day processing times for I-526. And maybe within 180 days, you're going to get the I-829 adjudications. Was this that promise? Or, what did you guys see in any relation to the fee study?
Yeah, I would say
No.
it looks separate from the RIA. Peter, correct me if I'm wrong here, but I just think that the RIA is probably still in pre-development in terms of what that fee study would look like. But they may be trying to get some signals from the overall USCIS procedure of doing their going through this process and getting feedback to try to figure out what a better number is. So it begs the question for me, how much IPO involvement was there in putting together this USCIS broad proposal?
So is there a gap then at USCIS or IPO, IPO being strictly EB-5 related, and then USCIS being the grand agency? Is there a chance they put out all these numbers without even talking to IPO? Like, how does that work at USCIS?
I'm curious what the depth of those conversations are, because IPO doesn't control their budget. They have to get approvals. They have to have other people who don't necessarily know what they're doing and what the changes would be in the future, and if there's meaningful changes, how do you forecast that, and how do you, from a budget standpoint, give the people what they need? Because IPO does need money. They need to hire more people. They've lost people. There was a hiring freeze and things went backwards. So they do need to have a better budget, whether it's through fees or something else. They do need help, but this looks to me like it's more of a higher level than IPO itself.
Interesting. Yeah, Peter, what did you see on this thing in relation to the fee study? Was there any language in there talking about it?
Yes, this notice for the proposed rulemaking expressly states that this is not part of that fee study that's required under the RIA. So under the RIA, the Reform and Integrity Act passed passed March 2022. It required USCIS to conduct a fee study within 12 months of passage of the RIA. So that would be March 2023. And then they would have 60 days to then implement that fee study. So then we're looking again in May 2023. So clearly this proposed fee studies, this proposed fee increase is something that's been in the works for a while, I think, and it's unrelated to the RIA fee study. And so in the rule, in this notice, it says that they're not precluded, USCIS is not precluded from, potentially raising fees with respect to EB-5 under the fee study. But these fees that they're not precluded to raise fees in the interim,
right.
in the while they're doing this fee study. So
right.
The final result may be the same. That these proposed increases, like again for I-526E going from just under 4,000 to over 11,000 for an investor petition, might be the same result, to achieve the same result, which was of course to hire more staff, to address backlogs and achieve processing times, like you mentioned, between 90 days to 240 days, depending on which petition we're talking about, I-526, I-829, and where the project is located, whether it's a TEA project, now referred to as a high unemployment urban project, HUA project, rural or infrastructure, or a non-priority project. So we'll see. We have to stay tuned for that fee study, because that's not due until March.
Yeah.
Yeah, I'm curious what the projected turnaround time is for each form type. I think earlier before we started, we were talking about the 956 had a projected adjudication time of 108 hours, which is just, I would like to put people under oath to substantiate that one, because everybody I worked with needs to tell the truth and would, if given the chance. Now, a direct 526 can take that long or longer. These become very difficult. But a regional center, where they're compartmentalized, where the project itself isn't even looked at, you're just looking at source of funds, this shouldn't take that long. And I get it. You need more money. Go after the investors, because they're showing that they have money in order to play. You already raised the fee to $800,000 from $500,000. Like, you went up 60% there. What's another 150% increase on the form? You know what I mean? It's just frustrating to see it.
Yeah, and let's kind of put that in perspective, though. Like the original 924, before the 956 regional center designation, you had to kind of do everything all at the same time. You're asking for regional center approval. You have to have an exemplar project, something that's real, that has job creation, business plans, economic analysis, security stocks. You have the whole package put together. So 956 turned into a, just tell us who you are and that you're qualified to do this. 956F took the heavy lifting of the actual asset, the actual deal, the job creation, and the rest of everything else. So to say that 956F isn't even on the list of changes, because it did get its fee, which was a beautiful 17,000 plus again. But that didn't change. That didn't go to 50,000. That doesn't require a specific review of an actual asset on an address that has like real land documents. It has loans. It has all kinds of legal things that, it's 1,000 pages. Right. But the ticket to play, the 956 to set up a regional center, that's 50 grand, like to get the door fee. And, interesting to see that. All it's going to mean is that there's no new players, and or existing regional centers don't want a new regional center to go promote economic growth in a place that they're not already existing, which is kind of strange. So,
there's on that point, and there's a lot of interesting information to mine from this proposed rulemaking. And on that point, though, I think there is some anticipation of lower or decreased participation from regional centers. So if you very deep into this proposed rulemaking, there are estimated workloads for fiscal years 2022 and 2023. Fiscal year for 2023 for our viewers ends on September 30th, 2023. So we're talking about the overlapping between 2022 and 2023. They're only expecting 62 I-956 forms. So that is, for regional centers, that includes regional centers that had to file after the RIA was passed in March. There was a deadline to file that at the end of this year, at the end of December, and then projection of this year filing. So 62, that's it. There were, if you look on the website, there were over 800 registered regional centers. And so I think we're seeing a drastic decline going forward in future projects, which is both good and bad. On the bad side, it's obviously less job creation, less economic stimulus to communities that need it. On the good side, it's a distillation or refinement and hopefully to offer more and more superior and higher quality projects and higher quality operators.
Right. And that probably yields a longer discussion on whether that is the actual net effect, because as for us that have been in this industry a long time, if you were given the ability to have more volume, to create more supply of EB5 and have more projects and have an easier time attracting additional investors, which means like our biggest hurdle is no secret. It's retrogression, backlogs, and processing times. And if we were not limited to a 10,000 per year quota and you were given 100,000, like would that actually dilute or call it diminish the quality of product that we put out as a team and as a firm? I'd like to say no, it doesn't. And you're looking at years past where you wanted a distillation, you wanted the flight to quality, you wanted some of the bad operators to exit the game and exit the industry. The market has kind of taken care of that itself to a certain extent. It's just, there's 10-year track records, 15-year track records of groups out here now versus call it 2012 or 2010 when there's really only like 2 or 3 years. You have 0 adjudications. Nobody knows what's going on, what works, what doesn't. That has kind of changed. So it's kind of, it's an interesting discussion. Like if USCIS thinks they're improving the industry by killing pieces of it. Through fees and like just charging you to death. So interesting.
Yeah, it's interesting too, because the RIA essentially deputizes the regional center to oversee its stuff better, right? And so it puts the onus on us to make sure that what's happening underneath us as a regional center is actually what we're aware of and what we present. So with the cost of the increased fees is also more responsibility. We welcome that challenge, but it's just funny because if there's only 62, what if there's only 50? Are you going to raise the number just because you need more income from somewhere? Like, I don't understand
the mathematics behind it. You know, like
right.
What is that arithmetic? Is the divisor the number of regional centers you expect to apply, but they need a total number to sustain? Yeah, that right. You better add some supply in there. Yeah, spread it around a little bit more.
What happens if there's only 6? Is it 450K?
Yeah, you're gonna get an invoice from USCIS.
Right.
No, that's not funny. We shouldn't even be smiling at that. Yeah, I smile because I'm dying on the inside a little bit. But the other discussion, looking at this fee study, you know, it's not part of the IRA. There are no promises attached to this with, you know, 100 or 90-day processing. Then Peter, you mentioned 240 for I-829s or whatever it might be. That means, like, you know, what do we win with this new extraction of financial compensation to USCIS? I mean, I guess it's the promise of potentially being able to hire somebody. Does that sound right? You know, like, what else do we get for our newfound contributions to USCIS?
Well, if when looking at and I mean, that's what we need to be sure we do, and all of us do, is to hold USCIS accountable, because if they are raising fees, you know, ostensibly to hire new staff and reduce backlogs, increase or improve processing times across the board, not just EB-5, but, you know, for asylum as well. That's great, but we need to be sure that they actually follow through. And I think that's part of the notice and comment period, the listening session. We need to make our voices known to make sure that that's actually what's going to be achieved. If you look through this notice of proposed rulemaking, they're estimating they need that this will raise, I think it's nearly $600 million, in part for hiring new staff. And my understanding is that what they're stating is that the workloads for 2022, 2023 is exceeding their current capacity by 10%. I think that's remarkably lower than reality. I think, given what we've seen as processing times, you know.
So now you're saying that they're only 10% behind the 8 ball. Like, that's what I'm thinking.
Yeah. Yeah, that's how I interpret that, and I feel like that's
10% too much work.
That's an understatement, because at the same time, they state that nearly 2,000 new positions are necessary to meet adjudication and processing objectives.
You said 2,000
in IPO or all of USCIS?
All of USCIS,
okay.
But that doesn't include asylum. Asylum, it said it needs another 2,000 positions just to process asylum on a timely basis.
Right, those backlogs are 8 years.
That's significant.
Yeah.
So yeah, I mean, if this leads to them hiring, you know, 2,000 new staff, and to meet their adjudication processing objectives, and just to remind our viewers, I'll have to find it on the USCIS.gov website, but earlier this year they had published a targeted processing times by form as to what their objectives would be. And notably, the I-45 adjustment status was 6 months. The I-526 petition was 6 months. The EAD, 3 months. Travel authorization, 3 months. I'm blanking at the moment what the website said for what their announcement said for the I-829 petition, but probably within 3 to 6 months. The statute itself says 90 days.
Yeah,
right.
So if that's true, I mean, if they are able to raise fees and actually hire 2,000 employees across the board, this isn't just EB-5, of course.
Right.
To achieve those processing times, then that would be a significant improvement. I'll just reserve judgment until and remain cautiously optimistic until we see what happens.
Okay, so
yeah, and it's
right here, quick question. So let's say Peter's right, and cautious optimism pays off. We get our 2,000 adjudicators. They say go. How long does it take USCIS to onboard 2,000 people, train them, and have them functioning where any of this pays off?
Yeah, it depends on the form type and their prior ability and what they're bringing to the table and how quickly they can contribute.
Can you give us some examples of like what you've seen?
Yeah. So like if you are going to be an asylum officer, you probably don't have any experience dealing with what the asylum benefit looks like. Even if you have immigration experience, you have to go through asylum training that can take 6 weeks on site. At least for me, it was. And then you still need to do a USCIS specific training going through the visa alphabet. That would take another 3 weeks there. So before you even stamp anything and you're, looking at the papers in front of you, you're looking at 9 weeks right there of external training. I mean, internal to your job duties. And then you're going to be looking at people. This is where you can accelerate quickly. If you're good at what you do, you're going to be able to work with mentors and develop the skill set that you need to interview and close cases out and do the research required to make a decision on a benefit request. And if you can show that you're good and faster, then you'll get put into the queue a little bit more quickly. It's still going to take a few weeks from there. But the other point is you need to retain these good people and make sure that you can keep them there at IPO. And my fear is that the GS requirements have gone down for new hires at IPO. When I was hired I was a GS 14, and that's a nice position in the
What's
government.
the acronym for GS? Just for all the
GS, government scale.
Government scale.
General scale. Yeah. And so there's levels that go up to 1 to 15, and then the 15 would generally be like a supervisor who's been there for a long time, maybe second level supervisor. In some cases, a first level supervisor. Most adjudicators across USCIS cap out at a GS 13, but at IPO, I was onboarded as a 14, and so were my colleagues. But with the new budget, they're hiring people at a GS 13 level. And so will people be satisfied doing GS 14 work, being paid GS 13 money, standing next to peers who are also getting paid GS 14 still? They're mentors, but at some point they want to collaborate and feel like they're on equal footing with them. It could be a challenge for people to stay in one place. They really have to love their job to be getting paid less than their peers to stay there.
Understood. No, and we don't really talk about that element of like really the human element behind USCIS, where they have to retain employees. They got to keep people, not just train them and not just charge us for the fees, but it does nothing if they charge us, hire them, try to train them, then they just leave. Yeah, so.
And then they leave. And EB-5 is incredibly complex. I mean, you guys know, but like for somebody who's gone through the adjudication lifestyle, even a JD MBA, I spent 5 years in EB-5, and there's still stuff I see, and I'm like, what is going on? It's really complex, and it's hard to do. You need great people.
Yeah, that makes a lot of sense. Makes it difficult. So we talked a lot about what is the fee studies. We saw what the numbers are, the changes. We saw 200% increases in all of our core petitions of the EB-5 world. And you see almost an on par number for I-526Es and 829s. From your history on the adjudication side, is there a big difference between your workload for I-526 versus the 829?
829 should be easier, but there's different elements that probably contribute to the total time required to complete it. I think there's less mental lifting in an 829. You're not really, analyzing whether or not the project works. You're looking at whether or not the money was made available to the project and whether it was sustained in XYZ. You're at the last stage of the benefit request, so you want to make sure that you're giving a good look at the individual petitioner there. You might be backwards looking into policy changes that weren't part of the initial adjudication. That could be challenging.
That sounds complicated.
There's more systems requirement, right, to close people out, but that's a lot of money. $9,500 for one 829 is, hopefully it works for them, because they were doing like 100 a month towards a backlog of 12,000. So it's something like that. Don't quote me on those numbers, but it's not far
Well,
off. So they got to figure something out.
So tell us a little bit, at USCIS with adjudications and looking at these petitions, is there any benefit with economies of scale? So if is a whole bunch of 20 of the same project, all 829s that are coming in, was there any special treatment or special tactic for that stuff? Or was it really just individual petitions?
It was discussed because there were different policy considerations. For instance, whether or not a visa was available to somebody from China, where somebody else had a visa available, you would prioritize them. And then based on when these things come in, you also need a reliable records department, which they've seen good records days and bad records days. Files can get sloppy, but to your point, I would rather see 50 cases from Hudson Yards related in a row than 10 different cases from different regional centers where I'm the first one looking at the project.
It's totally fresh.
Right. Yeah. Well, yeah, exactly.
No, and that makes sense. I think that's probably going to be universally true with anything you do, that if, the learning curve, the third one's going to be 3 times faster than the one you started with. So
similar countries are helpful too, because you have to learn about new countries the first time you see it.
And is that pertaining to like funds transfer? Like what's the country specific items that you would be interested in?
Things like source of funds, how cash transactions are dealt with, whether or not they're credible, what kind of evidence you would need to verify a cash transaction, where you've got Western banking and wiring that's easy to review, and the regulations because you live in this ecosystem. Yeah. It can vary, and even within places like India, it's huge, and there's a lot of different things going on all over India where you might have different cases within the same country where things do have some disparities too.
Right. No, that makes a lot of sense. Anything closing out this discussion of the USCIS fee increase proposal? Is there anything else we want to add before we kind of close this out? What do we think? Overall, there's a listening session coming up where we're not going to be told anything, but we're going to be able to all complain about what USCIS is doing is wrong. But what else do we got? Any other big points that we should pay attention to as this unfolds?
Well, I think from my perspective, even if it's not much, we should engage USCIS and hear them out to kind of at the listening session first, just to see what, if anything, they say that's incisive, and engage in the notice and comment period to at least put in a record and kind of to ensure that these raised fees are not only recovering operating costs, which is the official language that they're citing, but actually is used to improve processing times across the board for everybody.
Okay. So the final question to reiterate for the EB5 investor, new or existing, anyone that needs to file a petition, what does this mean for them today? Do they have new fees already, or do they have amount of time to rush in, get 526s, 829s, 45, get whatever petition you happen to have in hand, go file it? Do you have a moment in time here to keep the old fee schedule? Because it could save you tens of thousands of dollars here. Is that a yes, John?
I was keeping great.
Yeah. I figured I wanted to answer your question, but
we had to have one.
Yeah, I just want to have the straight story for the investors. It's like, if you file now, do you avoid increases, or are they going to come back and get you for a fee increase later? Like, how does this work?
Well, yeah, I mean, there's no doubt that IPO needs more money to operate. They've been through a lot. They are an expensive product, and for it to be good does cost money, and that will come from the investors. We're going to see how this shakes out. Obviously, I think the 956 fee is just silliness, and it's not credible at all. Like, talk about arbitrary and capricious. That's it right there on paper. But yeah, the fees will go up, and it's a matter of time. We haven't moved since 2016 in these categories, so it's inevitable.
Yeah. So, Peter's thoughts, like if you are a pending investor here about to file a petition, can you avoid the fee if you just file the fee increase?
Yes. I mean, you do have time. So, whether you're an existing investor filing, the existing EP5 investor filing your adjustment of status application, or the form I-485 and the corresponding forms for EAD and travel authorization, or you've gone through the entire life EP5 cycle and now you're filing your I-829 petition. You still have time before those fees increase. And new investors considering filing the I-526E petition, again, everyone has a minimum of 60 days before this rule would become final. It's probably going to be a little bit longer than that, just after they take in the comments, but that's the soonest, that 60 to 90 days, where you still have this time period where that you could file, and under the current fee schedule.
Yeah, I mean, the document itself, the proposal is already 400 or 500 pages. There's going to be a ton of comments, you would hope. So to get through all that and do a diligent job, if they're doing their work, then yeah, it won't be an immediate final rule.
Got it. Okay. Anything else before we sign off for this item with the USCIS proposed fee increase? Any last parting words here for the world?
No, I'm interested to see how it shakes out. This is the first time I've been on this side to see, the opportunity to be involved from the public and actually give my 2 cents, having seen both sides of it. I'm looking forward to comments.
Great. Yeah. Peter, any thoughts?
I'm, again, just remain cautiously optimistic that this leads to new hiring at USCIS to tackle processing times for everybody.
Yeah,
especially
absolutely.
Who have 13,000 pending petitions filed before the new law, and it'd be good to tackle those.
Yeah, I agree with you completely. And everything you guys said. As long as the money is well spent and it leads to an improved program and faster adjudications and a more higher integrity process, that would be money well worth it, except for that egregious 956 fee of 50 grand. So besides that one, you can keep the other ones, but yeah, that one, no. So thank you guys. Appreciate, signing off with Greg Sheehan and Peter Bibler and myself, Colin Baring, and we'll be back after the next news cycle here. So thank you, everybody.
Sounds good.
Thanks, guys.